Let me introduce our first panelist, Professor Gordon Smith, Chairman of AUS Inc. and Distinguished Professor of Intellectual Property Management at the Pierce Law College at Concord, New Hampshire. Mr. Smith is a well-known author, lecturer, and consultant who has advised clients in valuation matters for well over 40 years. He's been involved in appraisals of nearly every type of tangible and intangible property and is the founding chairman of the Intellectual Property Management Institute. Professor Smith.
Thank you, Mary. I would prefer to do this somewhat informally, so if we are going to have a question period after, but if something really is burning that in your mind that you really don't want to try to remember, raise your hand. We'll deal with it. If I'm going to talk about it later, I will tell you so, and we'll postpone it. I certainly agree with Mary that it's incumbent upon any management these days to maximize the use of all the assets of the company, and increasingly, obviously, those assets are intangible or intellectual property. Let me just, I don't use those terms interchangeably, just so that we start on the same page. To me, intellectual property is a subset of intangible assets. Intangible assets is the overall umbrella, and intangible assets that are not intellectual property would be things like the workforce of the company, advantageous contracts that the company has, customer relationships with distributors. Those are intangible assets. They can be extremely valuable, but they're not protected by law, and they're not commonly bought and sold either. But as a subset, then, you have the intellectual property, which does have legal protection, can be transferred more like other kinds of assets. So that's the distinction that I make between those two kinds of assets. And I also feel that when I say to managements, it's incumbent upon management to use and maximize their use of their company's assets, I use the term exploit. And you'll hear me say that. And I don't mean that in some nasty way. It's simply using an asset, in this case intellectual property, to extract the maximum profit from it. Now, to me, monetization is basically this kind of a transaction. It's a transaction between someone who owns intellectual property and some source of capital. We don't need to define what source of a capital it is, but that's what monetization means to me, an exchange of rights for cash. Now, securitization, to me, is a special kind of monetization. And it's special in the sense that the capital source is from investors who are buying some kind of security in the marketplace. But the result of that is the same as monetization. Somebody has a source of capital, whether it's themselves, a hedge fund, or marketable securities, and the owner is exchanging that for cash. So I say, I consider securitization, I don't use that interchangeably, securitization is a special kind of monetization. And in my remarks now, think in terms of monetization. I'm not going to address securitization per se. Securitization obviously can be an extremely complex business, because you not only have to make this transaction between owner and source of capital, but you have to satisfy all the outside influences of the capital markets, what investors want, what investors need. And in today's world, having gone through what we have gone through with strange kinds of securities, that becomes a very complex and expensive proposition. So, but I'm going to back up and address this really more from the form of monetization rather than that specific kind. And I'm going to also address my remarks from the standpoint of the IP owner, because I think that's most of what you are interested in. I'm an IP owner. I work for an IP owner. What can we do? How do we do it? What is this monetization about? So I'm going to do this from the standpoint of that, of the owner. Now, again, some definitions, if you will. The amount of cash that can be generated in a monetization can't exceed, is limited by the market value of the intellectual property. Makes sense. Under normal circumstances, you can't borrow more money from the bank than you are going to pay for your house. So that's why we are concerned with the market value of the IP involved here, and we're going to be talking about that. A definition that I prefer of market value is what I've shown there, the present value of the future economic benefits of ownership. What do I mean by the future economic benefits? I'm referring to cash income from future exploitations of some form of intellectual property rights. So there's three definitions there that are really kind of key to thinking about monetization. If I'm right, if you agree with me that the amount of cash that a monetization can generate is limited by the market value, let's think about what drives market value. And there's really three pieces of it, in my opinion. And these are the three. How much is that? How much income is there going to be? What's that future economic benefit in terms of dollars, total dollars? That's a driver of the present value or the market value. Secondly, I've got to consider the risk. What's the likelihood that that income is really going to flow to me? Because if it stops, that's certainly going to affect the monetization. Lastly, the life and the pattern of the income stream. If any of you who are familiar with the arithmetic of present value calculation, you know that it's very critical to know how long that income is going to flow and what is going to be the pattern of it. Am I going to have to wait a long time and watch it go up? Is it going to be steady? Is it going to be high at the beginning and eroding toward the end? Whatever pattern it is has an effect on the present value and therefore the market value. So these are the drivers. When I talk about value also, you must think in terms of economic life, not statutory life. The economic life of an asset, economic life of some intellectual property is the period over which it's going to produce profit. Has nothing to do with the statutory life. How many patents produce income for their owner for 20 years? Very, very few, if any. In the semiconductor business, they don't even bother patenting things. Technology is moving so fast, by the time you get the grant of a patent, it may be obsolete. So many of those things enter into it because they're concerned about what's the economic life of this technology, not the possible statutory life of a patent. So, large amount of future income, high value. Large amount of risk, low value. And both of those are governed by that pattern and the economic life. Now, any kind of property, intellectual property included, has associated with it a bundle of rights. The owner owns all of these rights, and they include some of these things. The right to use the property, and this holds true for real estate as well. This is, and land and buildings and machines as well. The right to use it, the right to sell it, right to lease it to someone else, right to give it away, or the right not to do anything of it, to refuse to exercise any of those things. What I would like to do, though, with you is focus on two of those, and that is the right to use it and the right to lease it, because these are the common ways that intellectual property is exploited. I call the first one the internal exploitations. That is, I keep all the rights to the IP. I use it in my company however I can. And the right to lease it is an external right, if you will. Now, what are the monetization opportunities for the internal classification? Well, I can use intellectual property as collateral for a loan. And that's increasingly happening because lenders are getting more used to the idea that intellectual property can be an adequate collateral for a loan. I've done quite a number of valuations of trademarks in the garment and cosmetics industry that were going to be used as collateral for loans. If you know anything about those two industries, you know that in many cases, the brand of cosmetics or apparel is maybe almost the only asset that the company has. All the goods are all manufactured by contract manufacturers, and so the company doesn't own any manufacturing facilities. It just owns that brand and perhaps relationships with distributors. Another is sale and leaseback, and I'm going to talk a bit about excuse me, some transactions of that. I sell the intellectual property to someone, thereby monetizing it, but I need to continue to use that intellectual property in my business. So I lease it back from whoever I sold it to. It enables me to keep using it, but I have monetized a portion of it. There's an outright sale, obviously. And finally, an IP holding company. I don't know if you're familiar with that, but it has been fairly common for companies to transfer a body of intellectual property to another wholly owned subsidiary holding company. And those holding companies are usually in very tax favorable jurisdictions. It's becoming tougher and tougher to do that because the tax collectors of the world are getting much more sophisticated about this sort of thing and recognize what's going on. But it does happen, and presumably that could be a reasonable exploitation of or monetization of intellectual property if there were significant tax benefits flowing back to the company. Now, looking at the external group, primarily this is via licensing, where we're exchanging the right to receive future royalties. I have made a license to you, you're paying me royalties. I then turn around and go to someone who's a source of capital and say, I will assign all this future income stream of royalties to you in return for a lump sum right now. So I monetize that income stream. That's probably the most common arrangement when people talk about monetization or securitization. One of the very early transactions that got a lot of press was the so-called Bowie bonds. The singer, what's his first name? I forget.
David.
David, thank you. He's not one of my favorites, so. he was entitled to a stream of royalties for many songs that he wrote and performed. And so he assigned that stream of royalties to an intermediate company, and that was funded, and he received a lump sum, and that company now collects his royalties. My understanding is that those bonds that were sold by the securitization entity are now classified as junk bonds. They haven't done well. And we'll talk about some of the reasons for that. So two schemes of exploitation, and we'll illustrate that here, the internal and the external. One of the very unique characteristics of intellectual property is the ability to exploit it simultaneously among various parties. And many times, many owners of intellectual property continue to use the intellectual property themselves in their own business, but can assign pieces of those rights to others. And that can be based on geography. I can say, you have Malaysia, you have Indonesia, you have Vietnam, and I can cut it up that way. I can do it in field of use. You're licensed to use my intellectual property in the automotive business. You're licensed to use it in to make washing machines. Because intellectual property sometimes can be multi-use. I can license it for time periods. I'll license it to you for 5 years, and then it comes back to me, and to you for 10 years, whatever, and multiple entities. So that's a characteristic of intellectual property that no other kind of property has. If you own an office building, it's an office building. You can't divide up the ownership among people in different countries. You can't move it around. But intellectual property obviously can be moved around. So we end up with multiple streams of earnings. One of the very important things in the monetization process is to establish the ownership, establish your ownership of the intellectual property that you're trying to monetize. Obviously, anyone exchanging capital for rights wants to know whether those rights are good or not. And that's not all that simple in a lot of cases. We've heard some, I heard yesterday, the cases of performers' rights, the copyrights, the creativity, work made for hire, a lot of issues that can arise that put ownership into a kind of a murky area. But those things have to be cleared up if you're going to use that, any kind of intellectual property like that in a monetization scheme. You also have to be very sensitive to the package of assets that you're monetizing. Let me give you an example. Several years ago, I was brought in by a major appliance manufacturer in the US, and their thought was, we need you to value the patents associated with our, I don't know, washing machine and refrigerator and freezer business, because we're going to sell them and lease them back. Okay? Started into this process, and I and the client both came to realize that that wasn't going to work, because the party that was going to provide the capital, monetize these assets, needed a marketable package of assets, and those patents weren't enough. In other words, they wanted to be able to, if my client ran into financial problems and couldn't make the lease payments, they wanted to be able to repossess something. And repossessing those patents wouldn't be very helpful because they could not, they weren't in the appliance business. They're in the money business. So the only thing they can do is take control of that and resell it to someone else. Well, the patents weren't necessary to manufacture washing machines. So they helped, but they weren't necessary. So what we finally realized and understood was that they would have to monetize a package of IP consisting of the patents, consisting of the manufacturing know-how that they had built into their manufacturing systems, because it's not all that simple to manufacture a good quality refrigerator. We also had to include the drawings and the specifications for those product lines, because if they were going to have a marketable package to sell, they had to give it to somebody and with all the ingredients that would enable them to make washing machines. And it included parts lists and names of suppliers and prices and everything like that. So we ended up valuing a much larger package of IP than we started because of that. They had to be able to deliver a marketable package in the event that my client defaulted on the payments. You need to be sensitive to what kind of a package you may have to put together to make monetization attractive. All right, again, talking about the external exploitation possibilities being licenses, then obviously we have to focus on the licensees because they're the source of the income streams that we're going to assign to someone in return for a cash payment. Think in terms of what makes a good monetization opportunity. First of all, the amount of that income. We look to those three ingredients that we need. Everything else equal, the more income stream, the larger income stream, the greater the amount of capital that we can obtain in a monetization. Second thing about it is the cost of monetizing or securitizing is pretty much of a fixed number. So you don't want to spend $6 to get a $10 monetization payment. But you might be willing to spend $6 to get a $100 monetization. So we have to be concerned about the amount that we're dealing in big enough numbers to cover those basic fixed costs of monetization or securitization. As to the life and the pattern, obviously, long life is better. More income, larger income stream. A growing income stream is more attractive. Having the income flow in the early years is more attractive to the capital source. If you know about present value accounting or present value calculations, you know why that's true. And obviously, having a low volatility in the income. An income that bounces around all over is not going to be terribly attractive to a capital source. Finally, that third, the risk of it. Obviously, the capital source is going to want a stable income stream. They're going to want to see that licensee out there that's responsible for that income stream, it has some financial stability, that the IP is contributing to a good market position. All these things go into it. Competition, the technology risk. What's the likelihood that this income stream is going to be cut off abruptly because a competing technology is going to take over and our licensee is out of that business? High quality underlying patents, make sure that the trade secrets are being well protected. In that case I told you about the appliance manufacturer, the manufacturing know-how was really in trade secrets, in the form of trade secrets. So my client had to not only verify to me or satisfy me that they were taking appropriate security steps to keep those secrets secret, but they also had to convince the capital source as well. So, good monetization opportunities. We got strong IP. It's commercialized. That is, it has a track record of income because we're selling an income stream. Successfully tested in the marketplace and a stable cash flow. Now, there is a natural tension, if you will, between, let's say, you, the owner of IP, and the source of the capital. Both of you have developed some kind of a forecast of the income that's going to flow in this transaction. And perhaps you both are going to make a present value calculation. Now, you made a present value calculation as shown down below. So you think this future income stream has a present value of $5 million. Now, what's the capital source going to do? They're going to take a far more pessimistic view than you as the owner will. First of all, owners are always optimistic. But even if you get rid of that, they're always going to look at it. They're going to want to reduce that income stream. Well, we don't think it's really going to be that big. So we screw down they may even want to truncate it. Say, well, we'll give you credit for 4 years worth of future income, but not 5 or not 10. That's just too long. We don't know what's going to happen out there. So we're going to push that back. So there's or they're going to say, we see a lot more risk than you do. And in these calculations, just take my word for it, the higher risk means a higher discount rate and a lower amount. So the capital source is going to look at these facts and say, well, we're going to cut this off, we're going to reduce the amount of money, we're going to increase the risk, and we think it's $3 million. Of course, money flies out the door at that point to you. But that's just the normal negotiation that has to take place, and the viewpoints between you and the capital source are quite different. Now, lastly, in my opinion, the present value of the future economic benefits of self-exploitation, that is, if you keep the IP, if it's worth something, if you keep the IP and exploit it yourself, is going to be worth more to you. The present value of that is going to be higher than any cash that you obtain in a monetization. Now, I've seen comments in the financial press, as an example, that loan-to-value ratio, that is the ratio between these two numbers in IP monetizations, ranges in the 10 to 40%. So, if you need $100, or you think you have an asset worth $100, you're likely to get 40. Or 30 or 10. If you're financing your inventory, loan-to-value ratios are 65, 70%. If you're financing your receivables, it could be 80, 85, 90%. So this, and that reflects the incremental risk associated with income streams that are attributed to intellectual property. So just keep that in mind. There's going to be a difference. I truly believe there's always going to be a difference. And it's going to be perhaps substantial in the case of intellectual property. I agree with Dr. Strauss yesterday, who said very few patents are really worth anything. That's fact. I believe it. I mean, I've seen it from appraising patent portfolios. There sometimes can be a portfolio value. Many industries like to collect portfolios of patents because they give them design freedom. They don't have to look over their shoulder every time they come up with something. Oh, we better check that out. No, because we own 1,000 patents in this area and we're probably safe. And if we get into a little problem, maybe we can trade licenses with people and take care of it without litigation. So there is some value for a portfolio of patents, but on an individual basis, very few patents have a lot of value. So keep that in mind as you think about the possibilities of monetization. I'm not telling you that it's always a losing proposition. There may be, in a startup company, that may be your only source of capital. And you may need that capital in order to invest it in something very, very lucrative. And that could be a great business decision and a good model. So it's not, I'm not saying don't monetize because you're never going to get what you want, but be aware that there are these tensions out there. And with that, I'll take my leave.
I would invite participants to come to the mic to ask questions. And if you do have questions, and I believe there's a portable mic around as well, and if you do have questions, please use the mic and also identify yourself and your affiliation as you ask the question. I'll give the first, Mr. Mohammed. Please.
Thank you very much, Mary, and also distinguished speakers. I enjoy both presentation. Maybe, Mary, you started with where you're saying that how the economy moving from tangible to intangible. At the same time, I think Su En finished the presentation by quoting the financial crisis. So I'm trying to bring these two, but Professor Smith, feel free to comment also. While we are moving from tangible to intangible, but don't you think as far as financial model, we are very much still depending on the old model of financial sector. You know, even if you see that at the UN, now UN Central, where they are discussing, trying to securitize the asset, they are still depending on the old financial model, financial instrument. And going back to financial crisis right now, there's also talk right now, it's about time to revisit some of this model, the way we securitize the asset. So what I'm trying to say, maybe, Su En, if you can share with me, how far have the development of financial sector has taken care, what you said just now, IP is evolving. In fact, we are talking about copyright. I think if we really want to amend our law, we have to amend every second to take care of the right that is being evolving. So is financial sector catching up with what is happening in the IP? Because otherwise we are playing football using a hockey stick. Is it the right instrument, or if not, given the opportunity right now to really skin the financial instrument, don't you? What are the sector that we should look at it, because so that we know that we have instrument that is meeting the IP needs. Thank you.
Gordon?
Well, in my former life, I was an expert witness on many occasions, and I was always advised to answer the question first off. And my answer to you is, I think the financial system is catching up. It is making progress in this area, but we're living through a deep financial blow to that, and it's going to make everyone nervous. The other thing that I see that is on the downside for that is what is happening on the internet and the we have a long way to go before the legality and the ownership of media content is sorted out, I think, worldwide. I mean, it's just, it's a free-for-all right now. And that, obviously, entertainment products and content products and databases and that sort of thing are a very, very big portion of the amount of intellectual property that's being traded around the world. I mean, entertainment is the U.S.'s biggest export. And so if that's in danger, then there's a problem. And until the legal side, and you're quite right, I think, that until the legalities of that and the ownership issues are sorted out, it's going to be very difficult to get any kind of financing in that area. But I would say, generally speaking, the financial community is recognizing that what is driving the profits of a Microsoft is not their building, it's not their machines, it's nothing like that. And if they see a good record, they know that they're going to have to get involved in using intellectual property as collateral or securitizing. So I think it's catching up, but I think there's some real setbacks at the moment that are going to retard that.
My name is Hui Fen. I'm from A-Star Singapore, Agency for Science, Technology and Research. Now, to put this question into context, what we do is we have a lot of research houses, and when the technology is viable, we try to spin these off into startups, private companies. The difficulty we often face is that we are not able to put a price on the technology that we spin off. This, especially when we're dealing with venture capitalists and other sources of funding. So my question to both speakers would be, could you elaborate on what's the most common method used for evaluating technology, whether it be patents or know-how? Would it be looking at the historical value of similar technology, or would it be trying to predict the future income stream of the technology? Thank you.
Gordon, go ahead.
You touched on the what I call a market approach. Do you look at what other technologies have sold and that sort of thing? That's almost a irrelevant methodology, unfortunately, for intellectual property, for any kind of intellectual property. In spite of the auctions and that sort of thing that go on, I'm very suspicious about the kind of property that's being sold there. Plus, but the main reason why that method doesn't work is that the whole legal system supporting intellectual property is aimed at not having similar properties out there. So if you don't have similar properties, then what does it help you to know what something sold for if it's so incomparable to what you're dealing with, you can't use it. So in my opinion, you are forced to make forecasts. You're forced to go through the kind of thing that Sue Ern was talking about here. Easy? No. Precise? No. But I don't see any other way to do it. What I do see, though, in your position, the kind of transactions I think you were describing, was a structure of a transaction that leaves the door open for some kind of a renegotiation or reset down the road. In other words, I've seen licenses where, okay, we'll make this deal now, but we're going to revisit it in 2 years because neither you nor the licensee knows what's going to happen. And so you do your best, and if you're having success, you don't want to leave money on the table. So that's a very common structure that I see with embryonic technology. Leave some kind of a door open for a reset.
That's excellent. Thank you. Good advice. In the area of valuation, whether it be norm setting, whether it be research, whether it be standards for valuation, do either of you believe there is a role for governments, national governments? Or is this something that, as we would often say in Canada, that governments rarely pick market leaders, and we should leave the markets to themselves. I won't be offended.
I wish you would please come to Washington and convince some of our legislators of that philosophy. But I guess kidding aside, I would think that there could be a sort of a potential conflict of interest or a conflict to be involved in the business side of property that you, in a sense, are creating. You are giving it the legal standing, and so you probably ought to stay out of whatever happens economically after that.
Valid point. So thank you again, both of you.